the legal system, the courts, it's not something most of us have anything to do with. We've been trying for some time, with the help of various members of the judiciary, to give a greater understanding and a look inside the courts. We've been speaking regularly to the Chief Judge of the County Court, Peter Kidd, and he is with me in the studio now. Judge, good morning.
Good morning, Neil. Nice to be here.
Well, thank you for coming in. A couple of things on the list today. And a lot of people ask this. When a judge makes a mistake, what happens?
Well, the judicial system is really designed to invite scrutiny of the decisions of all judges. And where there's a significant mistake, it's actually designed to expose that mistake and to correct it. So first and foremost, judges hear cases in public, the full view of the public. The parties are obviously present. They get a record of the trial or the hearing by way of a recording or a transcript, and they get written reasons of the decisions. The parties scrutinise those decisions, and if they want to assert rights at an appellate court at a high level, that's what they do. And then the High Court, independently of the initial judge or the original judge, scrutinises the decision and the reasons, and if there's a mistake, they identify it and publish their reasons. And that is the best way of scrutinising the work of the courts, and that's exactly why it's important. It's a part of the democratic process that courts are held in full view and transparently.
I'll come back to that. But that explains the examination and decision. It doesn't explain whether there's any consequence. If a judge, for example, has a history of, and you know, some people say, he's more lenient, this judge. I don't know if it's true or not, but that's what they'll say. If a judge has a history of lenient sentencing, for example, that is continually overturned on appeal, are there any consequences to you, or does somebody else go to that judge and say, now, hang on, we might be getting things wrong here?
Well, judges are always learning from decisions that come down from an appellate court as part of their education process. So if an appellate court has identified where they went wrong, then clearly enough, the judge reads that, takes that into account and tries to avoid repeating that error. Likewise...
So they're not carpeted in a sense?
Well, no, they're not, and they shouldn't be. Judges also undergo ongoing professional education through our judicial college, so we're always looking to improve the quality of our work. But, Neil, it's an inevitable part of the judicial process that mistakes are made. I mean, there's no other discipline or profession that I know of which is actually specifically designed to expose errors and mistakes, because that's part of the justice system. And the justice system shouldn't be afraid to identify mistakes and errors. If a justice system does become reluctant to expose those errors, then that's the end of the rule of law. We don't want we just don't want appellate judges or practitioners being afraid to find or assert error for fear that might affect the judge's career, or that might result in a judge being disciplined, for example. That would simply lead to defensive judging in the first place and defensive appellate work, which would be contrary to the rule of law.
Is it correct a judge can only be removed by Parliament?
In the end, yes, that's true. That's always been the case and still remains the case. But we now have a judicial commission in place, which is a body which hears disciplinary complaints, and the complaints can be made by any member of the community or indeed any litigant in question. The Judicial Commission only has jurisdiction over two types of complaints, though. Conduct which falls short of the behaviour ordinarily required of a judicial officer, and that's not just a legal error. That involves some sort of ethical offence, it might involve a judge inappropriately engaging in political debate, and we know judges shouldn't do that, for example.
Perhaps forgetting that they're no longer a barrister and going to a long lunch. I mean, I
don't know about that. But
I've never known it to happen in this state, but I've heard of other parts of the world where the judge comes back from lunch and dozes off.
Yeah.
I mean, how would you deal with that?
Well, it's that kind of behaviour that might end up at the Judicial Commission if they're dozing off, for example. And if that raised a capacity issue, or indeed if there was misbehaviour as such, then that could ultimately result in the matter going to Parliament for removal. So, for example, if a judge engaged in social media and on the social media posted messages which were racist and sexist and misogynist and the like, that may well result, and one would expect that would result in the possible removal of that judge ultimately. So there is a method through this independent body which oversights serious complaints concerning judicial behaviour, but that's over and above mere legal error.
Okay, any emails, questions for Judge Peter Kidd, nmitchell@3rw.com.au. What is a sentencing indication hearing? Is a question.
A sentencing indication hearing is, in broad terms, the parties come before the judge and seek an indication as to whether the sentence is likely or would result in a custodial sentence or a non-custodial sentence. It's got a very limited role to play.
James called earlier about a bomb threat at Bunnings. Thankfully, a false alarm. Everybody relax. Victims. Now, I suppose I've been dealing with victims of crime for 40 years, thereabouts, and a lot of them over the years have told me they feel brutalised by the courts. I get the impression it's improving, but what actually is the role of a victim in sentencing and the victim impact statements? And I must say, I campaigned myself. I think Joan Kerner was Premier to get that introduced.
Yeah, well, certainly in my career, and I have been practising crime since the mid-1990s, possibly the best development that we've seen is the increased role of victims in the criminal justice process, and in particular in the sentencing process. You made reference to the victim impact statements. By law, a judge is required to take into account the impact of the crime upon the victim when the judge sentences the offender in question. And I can tell you that those impact statements, they're sometimes read. They're sometimes read by the prosecutor, they're sometimes read by the victims themselves, and on other occasions the judge takes them into account in writing, but it's a matter for the victim as to how it's presented. And I can assure you, Neil, and your listeners that this has a terrific impact on the judge in question. It's often the victim impact statements are incredibly moving. So as a matter of law, the judge must take that into account. And of course, any sentence that a judge imposes must appropriately denounce the behaviour in question and punish the offender. And the judge is also taking into account the harm that's been caused to the victim when composing his or her sentence. So the impact upon the victim plays a central role in the sentencing process. But ultimately, victims don't sentence. They don't nominate numbers or the type of disposition. That's a matter entirely for the judge, as it should be.
I have known judges, and is this common? I have known judges who've told me privately in the past that when a victim's been particularly upset by a sentence, they think it's far too lenient, they've been known to meet with them privately and explain why, and inevitably the victim is accepting of it.
Well, look, I don't know about that practice. Certainly it's the practice of the DPP, or the Director of Public Prosecution, and the many hard-working solicitors there and their witness support groups to explain the sentence to the victims. Of course, when a judge sentences, he or she hands down substantial written reasons, which should also explain why the sentence has been imposed. But perhaps one of the challenges here is that whilst the victim does play a significant role in the process, judges sentence in the wider public interest. Now, the public interest, of course, includes the interests of the victims, but it extends beyond the interests of the victims, and a judge by law needs to take other matters into account. Now, some victims may be forgiving, some victims may be punitive, and they may not fully agree with the law and the matters that the judge must take into account, but the judge is required to take those matters into account.
You mentioned a moment ago open court justice being transparent. I couldn't agree more. But I was talking to Frank Vincent recently, who did a report on the number of suppression orders in Victoria, which far outweighs every other state. I know he was concerned. A great judge, Frank Vincent, I'm sure you agree, but and a very experienced judge, and was concerned about the number of suppression orders. Now, I can understand where there's a suppression order if a person's going to another trial. They're facing extra charges and you don't want it prejudged. I can understand the fact that victims of sexual offences aren't named. But it strikes, and it frustrates me, obviously, as a journalist, that so often we will know what's going on in a court and the public doesn't.
Well, each case needs to be looked at on its own merits, and there are always reasons why there's a suppression order has been put in place. You gave a couple of reasons. There might be others where perhaps for the protection or safety of a protected witness who's giving evidence against a co-accused, for example. But Justice Vincent's report also acknowledged that and recognises that overwhelmingly our matters are held in open court and not the subject of suppression orders. The number of cases where there are suppression orders is actually tiny. Now, that doesn't mean that we
Still
can't...
bigger than any other state.
Well, that may be so, but that doesn't actually prove anything.
Well, it proves Victoria's more secretive.
Yeah, well, we've got an Open Courts Act which we're applying, and every state has their own laws, and judges apply our laws, not the laws of New South Wales, and we apply our laws in relation to each individual case. And whether or not a suppression order ought to be made in an individual case needs to be looked at the facts. And Neil, if the media are not happy with the suppression order, and if the media contend that the suppression order is contrary to law, then they have appeal rights to go to a high court and to challenge that order.
But initially, you've got to fight the case with the person who's made the decision.
Well, of course, but that's the judicial process.
Yeah, that's fair enough. A caller says, what about the family court? Now, I know there's a lot of suppression there, and I support that because you want to keep children in particular protected from some of the awful goings on in the family court. One other thing I wanted to ask you, and there's been a lot of attention on this case only last week, what the politicians call, and we won't get into politics, but call mandatory sentencing in the area particular of assaults on emergency service workers, a mandatory 6 months jail. And it hasn't been happening. The politicians keep fiddling in and say that the judges aren't following the spirit of the legislation. Now, it's not really possible for a judge to follow the spirit of the legislation, is it?
No. Look, judges apply and interpret the law, which is made by Parliament, and Parliament, of course, represents the people. They've been voted in, and they make the law, and we apply it. We don't invent exceptions or special circumstances to mandatory sentencing. We've got an act. It's called the Sentencing Act. It's a complex document. In fact, it runs to nearly 500 pages. And the particular laws you were talking about there, the emergency services sentencing provisions, there are a number of explicit and carefully marked out exceptions to the 6-month imprisonment term. Parliament made those exceptions, not judges. When it comes to a judge is duty-bound to apply that law and to consider those special reasons, and that's what we do. Now, in the controversial cases in question, which I'm not going to go into in any detail, the judge found that they existed. And at the end of the day, he didn't invent those exceptions. They were in the Act, inserted by Parliament, and he was duty-bound to consider and apply those special reasons if he thought that they were invoked in that particular case.
Would it be fair to say that generally the judiciary and the legal profession itself is not a fan of mandatory sentencing?
Look, I think the point there is that mandatory sentencing is the opposite from what we do as judges. As judges, we look at all the individual facts and circumstances, we look at the relevant legal principles, and we attempt to tailor a particular sentence to meet the facts and circumstances of that case. That's the only way in which justice can be done in every case, because every case is different. Mandatory sentencing requires us to do the opposite. It basically says one size fits all when it doesn't, and that can lead to injustices. But the reality is, Neil, that the laws that you're talking about, they are not mandatory. Unfortunately, there's commentary out there which suggests there is, and I can understand why people then ask the question, well, why is the person not gone to jail if it's mandatory sentencing? The simple answer is that the community has been misled about what these laws are.
I won't ask you for comment on this, but the people who've been arguing they're mandatory are the people who run the state. We've got many messages coming through, questions for you. You've got a court to run. Thank you so much for coming
Thanks,
in.
Neil.
I hope we can catch up again.
Okay, thanks.
Chief Judge Peter Kidd.
Afternoons with DD.
James, who taught you to drive?